Thanks, Sean. Our next presenters are Jody Jones and Melissa Hampshire. They're going to be providing a regulatory update. I'll give you their brief bios here. Jody Jones served as counsel to the House minority in the West Virginia legislature before working in the natural gas industry. From 2009 to 2011, he served as counsel to the Office of Oil and Gas Division of Air Quality at the West Virginia Department of Environmental Protection as well. Since September 2011, he has worked for Chesapeake Energy Corporation, and he's currently Regulatory Affairs Advisor for the Appalachian South Business Unit. In October 2013, he was appointed co-chair of the OOGA Technical Committee. I'll introduce Melissa as well. Melissa has decades of experience in the oil and gas industry, and she has served as corporate officer in multiple basins in the last decade. In addition, she enjoys her current roles as a member of the OOGA Board of Trustees and as chair of the OOGA Environmental Committee. Melissa has held board positions on multiple industry groups across various states, there I said it twice, and has participated with those industry groups in creating industry best management practices. Jody and Melissa.
Everything all right? Thank you very much. I just realized that my bio is probably longer than my entire presentation, and for that I apologize. I do want to give a 30,000-foot view of some of the recent regulations that have went into effect, and some of those coming in the coming months. Luckily, we have Chief Simmers with us here today, and we discussed it earlier, and it makes a lot of sense that he is going to be the far more appropriate person to discuss some of the things. So he's going to come up and follow us on that and actually correct probably the numerous mistakes I'll make throughout my presentation. How do you use this? Is the big green button? Okay, so you probably want to look over here. That one looks a little weird. So obviously here's the important disclaimer that I'm giving this presentation on behalf of OOGA. It does not represent any regulatory agency or my employer specifically, and this also applies to Melissa as well. All right, one of the three big rules here we're going to discuss is the incident notification rule. Governor Kasich in August of 16 signed an executive order creating a one-call system for DNR for incident management, and also with the additional effect of it sent DNR's then draft incident notification rule into immediate effect. The rule followed up with the normal JCAR process. DNR and OOGA had worked pretty extensively in the first half of the year on that rule, and there was a great process that was put together for our collaborative efforts. Generally, the rule, specifically the rule covers sites that are regulated by DNR, i.e. your drilling permit sites, UIC sites, or orders, and also specifically covers registered brine haulers. On the type of events that the rule covers, as you can see there, blowouts, uncontrolled releases, H2S releases, fires and explosions and spills. Again, this is 30,000 foot. We're going to discuss a little more detail, but if you have questions about this specifically, there's some great information out on OOGA's table that Chief Simmers bought and you'll see a web link address in a couple presentations coming up. One important note that I do want to highlight on is that there is a provision in there kind of tying it all together, is that, so if you have a contractor who's, if you as an operator are not represented on site and you have a contractor doing work for you, and there's an incident that happens that would be reportable under this rule, then that contractor basically has a 30-minute period to make contact with the operator to notify them. But if that contractor cannot make that contact, then the reporting obligation falls on the contractor. And I want to make sure that everybody is aware of that. So kind of the key provisions on that. Number one, your crude and condensate spills are 5 barrels off containment if you're not in a sensitive area, which we'll discuss those here in just a few minutes. One kind of key item I want to highlight there is, when OOGA and DNR were working on the early stages of this rule, there was a lot of questions on some of these reporting limits, and we did actually be able to create a workable method where you kind of delineated between hydrocarbons that were produced on the pad versus hydrocarbons that were brought onto the pad, i.e. your drilling muds, your, oils for compressors, all those other refined products brought onto the pad for use, again, versus what you're making at the pad. But those refined oil products, your spill reporting limits 25 gallons off containment. For brines or sludges containing brine, it's 42 gallons off of containment. Hazardous substances are also reportable under this rule, but it just incorporates the existing federal standards for those RQs for those same hazardous substances. So while it's being reported to DNR now, it's not a new reporting obligation. Again, brine haulers are covered individually, and there's that 30-minute obligation where you're expected to report that incident to DNR within 30 minutes or as soon as practical, considering the circumstances. And lastly, containment has an excellent definition that the OOGA and DNR worked on quite a bit, and so it has covers pretty broadly all the different types of containment out there. So again, when you're looking at this rule, going back to those things, when it said 5 barrels or 25 gallons off of containment, that means that those spills have to eclipse your containment before it becomes a reportable incident. So here's a few quick things that have occurred recently, or not recently, but I kind of discovered them recently. This is oil and gases from their emergency response webpage, and I wanted to highlight a few things that are on there. There's an updated initial report form that looks really good. I like the tack that DNR took with that. There's also the 30-day follow-up incident form. There's the list of lists you can acquire from this same website, and that's actually all of the federal hazardous substances list, and only the federal government can title something the list of lists. And lastly, the reportable incident reference list, which actually there's some copies of out on OOGA's table now, in addition to some cards that you can carry around for your people and hard hat stickers with the number on it, which we'll see in a minute. Thanks again to Chief Simmers for those. And lastly, what I mistakenly thought as of just a little while ago, that the next step was actually GIS mapping, so an operator could plug in their well location and see if they're in one of these sensitive areas, which are 5-year times of travel for public drinking water wells, emergency management zones for public water intakes, 100-year floodplain, and I think the last one is urban area, although I can't specifically recall. But now those are available. The GIS mapping is live. So this is actually a snippet of the reportable incident reference list that I was referring to. So I encourage everyone, if you have any questions, go download this document and take a look at it and keep it handy for your operations and circulate it to all the people within your operations that need to see it. Next up, facilities rule. There's kind of two main questions that I generally get about this rule. Number one, in addition to what does it do, but why is it being done, and will it affect the upstream oil and gas operations? And so the answers to both of those questions are in the statutory code. And House Bill 59 from a couple years ago said, chief must adopt rules. So it's an obligation that he has. So in addition to that, it clearly states that what the subject matter of this rule is outside of the things that ODNR already has jurisdiction over. So those are the things, your 150906 permits and your orders, and all of those things that already capture the upstream activity that we do. These rules will capture the third-party kind of waste handling facilities that are outside of that are currently being captured through orders for the past several years from the chief. There's been several kind of iterations of the rule and some meetings, but now the rule is in a semi-final draft version. We had a large stakeholder meeting on January 30th. I do want to highlight that this rule is incredibly complex in its scope and detail, and it includes a lot of working parts, and I actually applaud DNR for doing a great amount of groundwork when it comes to working with the other agencies and how these agencies are going to dovetail with this rule and DNR's sole and exclusive authority. And this is not easy. There's still some hurdles and things that I think need to be worked through, but we'll definitely get there. So kind of generally on the rule, it'll set forth the permitting and operational requirements for facilities that where storing, transporting, storing, processing, treating, or disposing of any waste substance that outside of, again, a 150906 permit. So a couple of the areas where I discussed earlier where OOGA and DNR are definitely working together, and some of those areas are specifically the facility determination. What is a facility and how is it going to be defined in the rule? De minimis and T-norm testing. This kind of goes back to the question of the OEPA code section about cuttings and how much drilling mud is too much in the cuttings, and also T-norm testing procedures, some protocols and guidance out to further kind of standardize what you're seeing in the industry out there. Baseline assessment, that's the process of when an operator is attempting to locate a facility, what environmental information do they need to collect, so that way when down the road, when that facility is closed, you can demonstrate that there has been no long-term environmental impact. How are existing facilities that are currently operating under a chief's order going to be treated under the rule? And lastly, financial assurance. And my last slide is spacing. On January 17th, DNR presented to, actually Oil and Gas presented to the TAC some proposed revisions to 1501-9-104, which is the spacing regulations. And those the proposed changes include a 50% reduction in the minimum acreage size for all units, regardless of the depth of well, regardless of vertical or horizontal. Also, would propose the formal adoption of take point spacing, 150-foot toe and heel spacing for horizontal wells as defined by statute, and also 350-foot spacing to the parallel unit boundary for a horizontal well, and the box rule, which is allowing a percentage of deviation in the lateral before it would be determined to be out of compliance. The TAC unanimously approved the division's proposal, and rulemaking should begin probably in the next month. I think there's a few things to iron out, and I do want to clarify that when DNR's proposal and the TAC's approval is essentially creating a guide map for what DNR can do going forward when it comes to its rulemaking. So effectively, DNR can create minimum toe and heel spacing as low as 150 foot in the rule, but they could not now, unless they wanted to go back to the TAC, say it would be 125, because again, DNR has approved the TAC has approved the floor, and so now DNR can go anywhere between current regulations and kind of the floor that TAC approved. So those are all my slides and all I have. Melissa?
Good afternoon, everyone. Can you hear me good, I guess? There are pillows and blankets in the back of the room for any of you who want to have a nap. No, I'm only kidding. So what I did was I tried to organize some of this stuff for y'all, so it was, I only have 15 minutes, and you know I can get off on a tangent about, various regulations. So I'm trying to organize this for you. We have the state ones up. Okay, so with our fearless leader, Chief Simmers here, I'm not going to go over any of the ODNR regs that are currently in the works or pending. I'm going to talk about some of the other ones. So ones to be concerned about in the state of Ohio is the 401 water quality certs. The 401 water quality certifications were proposed by Ohio EPA and the Army Corps. The Corps' nationwide permits are now final, so the Ohio EPA proposed new water quality certifications. What they wanted to do was send it to the Corps to get approval for the midstream portion of it. The Corps did not give those approvals, but you know that the nationwide permits moved forward. So what Ohio EPA is trying to do is align that with when the nationwide permits are coming out with the Corps. So that will be on March 10th, I believe, March 10th is the final date for that. So please keep a watch out for that. You're going to need to know those. Pipelines are covered under the nationwide permit number 12, and remember that was a sticking point with the midstream stuff, so just in case you're interested in looking at those. We did, as the OOGA Environmental Committee, comment on these back when they were first proposed. So we feel that they're pretty much in line with where we need them to be. I'm sorry, did I say the 10th? On the 19th, March 19th is when you want to watch that. General permits for compressor stations. The Ohio EPA has proposed general permits that apply to air emissions for natural gas compressor stations. Now with that, I'm talking about well sites as well. So if you have engines and whatnot on your well sites, this will apply to those as well. And what they were trying to do is streamline the permitting process, make things a bit easier. So there are, when you look on Ohio EPA's website, you'll find the various, I don't know, I think there's like 17 different general permits. I'm not sure how many, but you'll see as you're going through it. And there's general permits related to different kinds of compression, different kinds of engines, flaring, things along those lines. So you're gonna wanna look at that. They are final. So I encourage you to get on Ohio EPA's website, look those up. And they also have some great supporting documents in there. You'll be able to calculate your own emissions. They have worksheets and some other guidance documents of the various things that you're gonna need to submit with your application. So I encourage you to get in there. And even if you're not gonna use them right now, look around and see what's offered. The startup, shutdown, and malfunction. Ohio EPA they have posted the startup, shutdown, and malfunction rule to attain and maintain the 2012 National Ambient Air Quality Standards for particulate matter that's less than 2.5 microns. So I'm sure a lot of you are aware that that was going on. The rule covers permit to install and operate program rules. The Environmental Committee commented on the SSM rules in December, and a hearing was held in January. So we couldn't establish this today, but they're either in the Common Sense Initiative or JCAR, so they have moved forward. I believe that you can get the draft rule. Am I right in saying that, Penny, that you can get the draft rule for SSM off of their website, off of EPA's website? So I encourage you to get on there and look at that. Even though, you know, it's not final yet, you know, it's in some stage of finale, which is CSI or JCAR. All right, so that's all I'm gonna say about state stuff, because I'm sure the chief will cover a lot of that state stuff for you. So on the federal, you know, a lot of things have happened on the federal level. It's been for once, a very exciting time for our industry, as a lot of the things that a lot of environmental and climate change type rules have been rolled back, or and have with the previous administration have really slowed our ability to move forward as an industry. So I'm going to touch on a few of these. I know that Sean recently talked about the information collection request, but the information collection request in the waning hours of the Obama administration was introduced to collect data from our industry. It was solely for our industry. And it was to collect data in hopes of further regulating the oil and gas industry. And that's the sole reason for its collection. So I believe some time ago I encouraged some of you to move forward with asking for an extension in hopes that we would see some kind of help with this information collection request. Anybody who did do the information collection request understands that the survey questions did not make any sense. There were a lot of things on there that were very confusing. It ended up costing people a lot of money because you needed consultants and whatnot to be able to do the calculations. So, and then, you know, for an industry that's voluntarily minimized, you know, methane emissions, it was quite cumbersome, to say the least. So, on March 2nd, the US EPA, under the Trump administration, withdrew the request, so you no longer have to do the information collection request. Let me see here. Is there anything that I definitely want to tell you guys? Oh, if you want to see the ICR notice, definitely go to US EPA's website. Scott Pruitt put it on there for the notice for the removal of that, so you have something for your records. The regulatory freeze and reform. Near the end of January, the White House issued an executive memorandum implementing a regulatory freeze and proposing regulatory reform. In the memorandum, regulations that have been published in the Federal Register within the 60 days of, okay, so this is a bit of the confusing part. It said that they'll be reviewing regulations that occurred, that were finalized within the 60-day window before President Trump took over. So it's 60 regulatory days. So actually, they're looking at regulations that go back to June 17th, because that's 60 days in federal speak. So a lot of the regulations that you thought were done deal may not necessarily be. They're up for review. Along with that, there was a regulatory freeze. So anything that either was A, sent to the Federal Register for publishing and not published, or B, finalized and not sent to the Federal Register, are frozen until they can be further reviewed. In addition, any new regulation that's created, two old regulations have to be done away with. So there's some various things going on in the House, in the Senate, in the various agencies to look back on some of these regulations, and I'm going to talk about some of them here. If you're interested in seeing the regulatory freeze memorandum, it's on the White House's website, and it kind of outlines, what can be expected with that. The U.S. EPA, in conjunction with the Army Corps, issued the Waters of the United States rule last year. The rule allowed the federal government to extend its reach over bodies of water that they weren't previously regulating, and claiming it under the Clean Water Act. Many states and industry groups sued EPA, that's federal EPA, claiming that it harmed their industries, simply because now not only is it basically a giant federal land grab, it made it more difficult to be able to work, because now dry ditches, timber ruts, things along those lines are now regulated under the federal government and under the Clean Water Act. So an executive order was issued by the White House, and it's on the White House's website as the Restoration of Rule of Law. So if you're looking for that particular one, Restoration of Rule of Law is the name of that one. And it's the first step in rolling back WOTUS. So anybody who's interested in WOTUS or have been following WOTUS, that's the name for Waters of the U.S., and also it kind of stops everything that's going on in the courts. But you can view that on the White House's website. And like I said, it's under Restoration of Law. And that is an executive order. Also in that executive order, it calls out to for regulatory agencies and the legislature to actually define what's considered a navigable waterway. Because obviously a dry ditch on some farmer's field is not a navigable waterway, but the way this rule is written, that is considered a navigable waterway. So that is also going to be reviewed with this executive order. Toward the end of last year, US EPA finalized the Quad-O and the control technology guidelines for the oil and gas industry. So it's Quad-OA. At that time, multiple states and industry groups sued the US EPA for substantial economic impact of these new regulations. If you recall, the Quad-O regs require the oil and gas industry to install control devices for VOCs and methane, do extensive leak detection programs, things along those lines. Green completions are also covered in that. In addition, the rule required the implementation of the extensive reporting requirements associated with your giant leak detection programs. Remember, if you make modifications to existing equipment, you now fall under the Quad O regs. So even you know, I think at this point, if you don't do anything to it, you're okay. But if you make a modification to the piece of equipment, it then falls under the Quad O requirements. In association with that, a regulation to watch is BLM's flaring and venting. BLM is Bureau of Land Management. They have a venting and flaring rule that they put out that is very in line with these Quad O requirements, you know, extensive leak detection programs and whatnot. The most difficult part of the BLM venting and flaring rule is that it applies to the conventional operator too, and it makes the conventional operator go back and redo equipment. That's like installing your pneumatic controllers, things along those lines. So imagine what damage that would do to your LOE. So that's one for you to watch, especially if anybody is working in the Wayne National Forest. That falls under the BLM stuff. Last month, the House passed a joint resolution under the Congressional Review Act to repeal the BLM's flaring rule, and that bill is now in the Senate. The critical habitat rule was introduced by U.S. Fish and Wildlife and the National Marine Fisheries Service, and expands the rules by expanding the areas of jurisdiction to the areas that were previously not occupied by a threatened and endangered species. Now, what that means is, say we have a critical habitat and it's designated as this large. Now we've made it some unknown, giant, large area, whether that species is there or not. So imagine that you have a back corridor that you clearly know about that could be expanded to a much greater area because there's a chance that that bat might be in that area sometime in the future, which is, you know, as you can imagine, is very difficult to I don't know how to say this, but anyway, the critical habitat now just expands beyond what it should, because we know where these species may exist, and now it's passed to a much greater area. Multiple states have sued Fish and Wildlife for their definition of critical habitat and adverse modification, as well as I'm wanting to know how unoccupied areas can be essential to the conservation of a species. So if they're not in there, how can it be essential to their future promulgation? So you want to watch this rule very closely. I believe a copy of that rule is on Fish and Wildlife's website. Another one is the Bat Habitat Conservation Plan. Some oil and gas operators are working with U.S. Fish and Wildlife as kind of a consortium group to try and get an incidental take permit for 5 different species of Indiana bats. Last year, towards the end of last year, we were allowed to move forward as an industry for incidental take permits. And there is a consortium about, I think there's 7 companies in the group that have gone to try and do this. And it's quite an extensive program to try and be able to get an incidental take permit. So that's something for you to watch. You know, I'm sure under the National Environmental Protection Act, which is NEPA, they'll prepare an environmental impact statement and all the various other things that go along with that. So definitely one to watch how this progresses. And right now they're doing public scoping meetings. So if you are able to attend the public scoping meetings, I encourage you to do so. The Endangered Species Act is up for changes. Something to watch is House Resolution 717, the Listing Reform Act. It was introduced in the House in late January. It amends the Endangered Species Act to take into consideration the economic impacts of adding species to the list. It does a few other things too. You know, right now there's 1,600 different animals and plants on the list. It gives, it basically stops the environmental groups from being able to sue to get a species added to the list. It also takes away the requirement to review for species to be added to the list versus species to be taken off of the list. So there's various other things. That Listing Reform Act is, again, House Resolution 717. If you're interested in looking that up, I encourage you to do that if you have time to do that. I think the biggest thing, the biggest takeaway with the way the Endangered Species Act is, is basically through them suing, they are, and I say them meaning the environmental groups suing, they're forcing things to be added to the list without the science behind it. Okay, so definitely keep an eye on that one. The rusty patch bumblebee, also in the waning days of the Obama administration, U.S. Fish and Wildlife listed the rusty patch bumblebee on the threatened endangered species list. Sean touched on it briefly earlier in his speech a little while ago about their ability to burrow under the ground. There's really been no focus other than like a 7 or 8 or 9 state region where these bees could be. It's kind of not based on solid science of where they could be. The listing is it was originally to become effective in February, but they since pushed it back to March. So they're reviewing that in conjunction with all the other things that they're reviewing. And, it was frozen as part of the regulatory freeze. The effective date for that one is March 21st. So the rusty patch bumblebee may be on the threatened and endangered species list as early as March 21st. So please keep that in mind. Please look on U.S. Fish and Wildlife's website for information about the rusty patch bumblebee. Pretty much anybody who moves a teaspoon of dirt is at risk of damaging the species according to the way this is written right now. So please get on the U.S. Fish and Wildlife site and look at what they have written there about the rusty patch bumblebee and kind of give you a bit of a flavor of if this isn't modified substantially, it could be very impactful to your day-to-day business. Okay, the environmental assessment of the Wayne National Forest. The Bureau of Land Management and Forestry took on an environmental assessment of the impacts of leasing in the Wayne National Forest. The Wayne National Forest the majority of the Wayne National Forest is privately owned surface. Better than 75% of it is privately owned, but however, it's in that federal designation of the forest. The federal minerals went up for auction. We had the first auction already. Second auction is coming up here soon. The environmental impact statement came back with no significant impacts from oil and gas activities. So they did a review. They found that there would be no significant impacts to the forest by oil and gas activities. Of course, various anti-oil and gas groups have sued to have that looked at and that environmental assessment redone. In the meantime, though, I believe the lease is still on with the BLM. It is a good time to bring up that BLM's venting and flaring rule. So if you have conventional wells in the forest, or if you're going to be leasing more minerals in the forest, you want to keep an eye on that venting and flaring, BLM's venting and flaring rule. So I realize this is a lot of information for everybody, and I couldn't possibly go through all the different things that are going on, but it's some of the regs that are going on, and I hope that you have enough information to be able to go back and look at some of these things that I've talked about, and if you have questions, certainly, Penny is always available to be able to answer your questions, and I'm available. I think pretty much everybody has has some way to get to me through Penny. So please, if you have any questions, I encourage you to get in touch with Penny on those. And now, with no further ado, our fearless leader, Chief Simmers, do you want to come up here, Chief, or? Okay, all right, great.